Yeah.
Okay, we're going to move on to our next question that comes from Eddie. I've heard that some states place a cap on the amount of money you can win in a lawsuit. Is that true? And what if the amount of your damages is more than the amount allowed? And that question comes from Eddie.
Yeah. Eddie, that's true. Mississippi does have a cap. The cap can be different based on a couple of different scenarios or different types of lawsuit, but generally speaking, there is a $1 million cap on non-economic damages in Mississippi. Non-economic damages are things that don't have a specific dollar amount attached to them, such as pain and suffering. And so, you know how much your medical bills are and will be in the future. So those are actual damages, economic. We know how much they are. And ultimately, you would have the jury would decide, or an expert would decide on what the pain and suffering amounts were. Oftentimes, we find ourselves in trial where the jury does award more than the cap for pain and suffering. And if they do, it just gets decreased down exactly to that $1 million mark. So there is a cap here in Mississippi. Other states may be different, though.
The worst part about the cap is we don't tell juries that their decisions don't matter. The insurance industry and the medical industry got together around 2002, 2003, 2004 and put a cap on damages, not because it's fair, not because it's constitutional, but because it benefits them making more money. And when they did that, they told juries that what you say doesn't matter if it's over and above the cap. And so if a jury comes in and hears 10 days of evidence and proof that someone's a paraplegic and that they will need help for the rest of their life to eat, to bathe, that they'll have pain and convulsions, and that they'll never leave their wheelchair, that they'll always need someone to help them 24-hour attendant care. And the jury decides, you know what, that's worth $3.89 million over the next 25 years. It doesn't matter. The judge is duty bound to cap that amount down to the cap after the verdict. I think it's ridiculous. It's so patently unfair. It cannot be defended. Now, they'll come in and say, here's a reason why it helps stabilize the insurance industry. Well, let me tell you, the founding fathers, when they said that we had a right to a jury trial in civil cases, they weren't worried about the insurance industry making billions of dollars. They were worried about protecting the rights of a citizen who was hurt by someone with way bigger financial means to have a right to go into a court and have a jury trial. The founding fathers, I think, would turn over in their graves if they knew about caps on damages. It's simply ridiculous. The worst part is our Supreme Court still hasn't addressed it. And it's been 15, 16 years since the law was passed. I had a case up there trying to get them to overturn the caps, and they decided the Court of Appeals dismissed it on another, or reversed it on another issue. They didn't even get to the issue of the caps. They need to decide it. I don't know why they won't do it. It needs to be addressed.